Hi, this is Stephanie Dirks, and I'm here with my colleague Jason Cahoot. We are attorneys in Foley's Estate and Trust Practice Group in the Milwaukee office, and a lot of our practice focuses on working with closely held businesses and doing their estate planning and business succession planning. So we thought it might be helpful to do a presentation for general counsel of these family businesses and just give them some background on some basic estate planning and succession planning concepts they may run into while working with a closely held business.
Over time, we've had the experience of having very qualified attorneys become general counsels of family held corporations. They really know their stuff, but like many lawyers, they find that estate planning is a little bit old, archaic, and counterintuitive. So we thought of this presentation as a way to address some of the common questions that we have or just get people up to speed on this topic.
We're going to start off with the gift and estate tax. So what is gift and estate tax? Well, starting with gift tax, a gift is any time that you give something to someone else for no consideration, that is going to be a gift that's potentially subject to a 40% tax rate. So for example, if I were to give my daughter a gift of Apple stock, that could potentially be subject to gift tax. Now, there are some exceptions to this. The first is that there is an annual exclusion. So you can give anyone up to $18,000 without incurring any sort of gift tax. So I could give my daughter Apple stock that's valued up to $18,000. There would be no gift tax there. Similarly, my husband could also give her Apple stock worth $18,000 and there wouldn't be any tax there either. So spouses can, each give $18,000 to one individual without incurring any sort of tax. There are some other exceptions as well, such as gifts to charities, or if you want to make a gift on behalf of someone else to pay their medical expenses or education expenses, although you would have to make those gifts directly to the healthcare institution or the education institution. Additionally, everyone also has a exemption. And so you can give gifts up to $13.61 million during your lifetime without actually incurring any gift tax. So how does that work? So let's say I were to give my daughter Apple stock valued at $19,000 in 1 year. And so I'm now $1,000 over the annual exclusion amount, but that doesn't mean I'm going to have to pay gift tax. Instead, I just use some of my lifetime exemption amount. And so eventually, if you make gifts over 13.61 million over your lifetime, then at a certain point, you're going to have to start paying gift tax. And I do want to note too that in 2026, this 13.61 million amount is set to sunset to approximately 7 million. So it's going to be significantly less in the future. Moving on to the estate tax. So again, at your death, the IRS is going to take a snapshot of all of the assets that you own, on your date of death. And if on your date of death, those assets are valued over 13.61 million, you potentially will have to pay an estate tax of up to 40% on those assets. So let's say I die today, my estate is valued at 14.61 million. I'm 1 million over that 13.61 exemption amount. That means I'm going to have to pay $400,000 in estate tax on my death. Now, let's say my estate's valued at 14.61 million, but I gave every single asset I own to my husband. In that case, I wouldn't owe any estate tax because any gift that you make to your spouse on your death is not going to be subject to estate tax. Similarly, if I left my entire estate to charity, that also would not be subject to estate tax either. And again, that estate tax exemption amount is set to decrease to 7 million in 2026. And I also want to point out that, the lifetime gifting versus the estate tax, they're all tied together because let's say, during my lifetime, I make gifts of 13.61 million. Well, then at my death, all the assets that I own would be subject to that estate tax. So you can either make gifts during your life up to 13.61 million, or you can do it at your death. You use that amount. So it's applied during life or at death. Slide 5. So how does the estate tax work? Well, this just kind of shows that, you have an older generation and they're going to pass on assets to a younger generation. And we're just kind of showing here, if you have an older generation, let's say it's a business owner and he owns assets worth 50 million. Well, if he dies today, then they're going to owe estate tax of around 14.5 million, which is going to leave around 35 million to the children. Let's say they were to instead die in 2026 when that amount gets decreased to only a 7 million exemption amount. Well, they're going to have an estate tax of 17 million and they're going to leave about 32, 33 million to the children. So it'll be significantly greater estate tax coming up in the future here.
Two things to point out about this slide. We put a dotted line there. Basically, the way the gift and estate tax works is that any transfers from a senior generation to a younger generation without planning will be subject to this tax. Now, if you're under the exemption, right, if your total assets that cross the line either during life or at death are under the exemption that's in effect at the time of the transfer, then you'll be okay. You won't have to pay estate tax. Anything in excess of that amount would either be subject to a gift tax or an estate tax of 40% for federal. It's also worth saying, if you're unlucky enough to live in a state that has a state estate tax, you'll have an additional burden. And because things are complex, sometimes that burden the exemption is not the same. So you have one exemption for Illinois or Minnesota purposes or New York purposes, and then you have another exemption for federal purposes, which makes things delightfully complex in those states.
Slide 6. The estate tax in particular can be challenging for business owners because you're going to have to pay that estate tax 9 months after you pass. And how are you going to do that if the bulk of your estate is comprised of a closely held business? So let's say, for example, you own a business that's worth 100 million. You're going to owe 40 million 9 months after you pass. And how are you going to pay for that? Well, there are some solutions such as doing an installment plan with the IRS. So you could pay that tax bill over a term of years and you are going to be incurring interest on that. Alternatively, you could get life insurance to help pay for that estate tax, but you have to think about, are you going to be able to easily obtain that life insurance? If you're older or if your health isn't great, it could be kind of difficult to obtain, or alternatively, it could just be very expensive. Additionally, you're going to have to do more planning to make sure that life insurance isn't also included in your estate and increasing that tax bill even more. Or you could do lifetime transfers that are really timed in structures to reduce estate tax at your death. And that's a lot of the planning that we do here.
Stephanie, yeah, the real, let's talk about the real negatives, like failure to plan. And that is, you might be looking at a sale, right? An unanticipated sale, or for many of our family business clients, the objective is to keep the business in the family for the long term, dare I say perpetual, but for the long term, so that the next generation, especially if their livelihoods depend on running that business, right? Or that's their business is to be the executive of that business, or that their employment is to be executive of that business. The focus is on taking a look at the estate tax. I would say for many family businesses, planning around the estate tax is it's a key element of succession planning.
Slide 7. There are lots of different ways as a business owner that you can, transfer the business to a younger generation to help reduce that estate tax bill, at your desk. So that the senior generation is, thinking how can they transfer assets to the younger generation? So how do they get from one side of that dotted line to the other side of that dotted line to help reduce the estate tax that they're going to owe at their death? So one thing we do a lot is to transfer non-voting interest. So the senior generation may retain the voting interest, so they're still going to have voting control, but they're going to transfer the non-voting interest interest to a younger generation, and that's going to allow that economic benefit of that non-voting interest to accrue to the younger generation and removes it from the older generation's estate. And there's a lot of benefits of doing this during your lifetime because you can get potentially what we consider minority or liquidity discounts on the value of those interests. So for estate tax purposes, or gift tax purposes, the value is going to be considered less than the fair market value. The fair market value might be worth 100 million, but because there's no, they can't vote these shares, and you're giving a minority interest for gift tax purposes, it might be considered worth 80 million, and that's beneficial because it means we can transfer more assets to the younger generation and not have to pay as much gift tax on that during life. Also, a lot of times what we like to do as well is think about, okay, is this a business that we think is really going to grow and take off in a few years here? If so, now would be a great time to do it. So all that appreciation, that future growth is removed from the older generation's estate and moved, to the younger generation. Or if there's an upcoming sale, again, a great time to do some planning there.
So what Stephanie is talking about is a concept that the gift tax applies only to what is gifted. So if, back to our example of a $100 million company, the older generation may have a $100 million company, and if somebody got an appraisal for that company, it would be $100 million. But if a person who owns it decides, I'm going to give 10% of my company to my child, right? And he's just going to give 10% of the stock, he would do that, but the value of a closely held company is not 10% times the value of the company. It's 10% times the value of the company. So in our case, $10 million. In addition, there's a discount that's applied because a closely held company that may or may not make distributions and may or may not have a path to liquidity is worth significantly less than just a portion, the percentage ownership of that stock. So, that discount could be from 30, 40, 50% of the value of that interest. So instead of making, if you make a 10% gift of $100 million company, the value for purposes of applying the gift tax may be something like $6 or $5 million, $5 or $6 million. If you do that over time, making a gift every few years, you'll find that your overall basically the amount of gift tax exemption that you use is significantly less than the alternative, which would be, if you were to make a gift or die with 100% of the company, then 100%, in my example, $100 million would be in the taxable estate or subject to gift tax. What Stephanie is also talking about is the freeze, which is if you make a gift today at today's value and your company's worth $100 million today, right? You've made that gift, it's not going to be subject to estate tax 10 years from now, when if the company is worth $300 million, the interest that the inheritor or the person who received the gift is going to be worth maybe $30 million. So using timing, just timing and deciding how you're going to make gifts over time can significantly decrease the amount of the estate or gift tax that is paid.
And now, as we're talking about all these different types of gifts that you are thinking about doing, and you're probably thinking, well, okay, that sounds great in theory, but really, I don't just want to give my children outright all of these assets. So how are we going to make this gift? Because I don't want to have them to just have outright ownership in the company. And so that's where a lot of trust planning comes in, and that's what our next portion of the presentation will really focus on. Will be on trusts. Slide 8. So now we're going to talk a little bit about what are trusts. So a trust is a relationship between a settlor, a trustee, and the beneficiary. So the settlor could also be called a grantor or a donor. This is the person who is making a gift or a bequest to the trust. So they create the rules about how these assets are going to be held, who the beneficiary beneficiaries are. They're going to pick out the trustee. So they're the ones who are making the gift, transferring the assets, and who are kind of deciding the rules about how these assets are going to be held for the benefit of the beneficiaries. The trustee is the party that has control over the assets. And so they're the ones who decide if and when the beneficiaries are going to receive any distributions from the trust. They are also the ones who are generally going to manage how those assets, are invested, how you're going to control them, kind of any sort of thing that has to do with the asset the trustee is going to have control over. Now, sometimes that trustee could be one person, sometimes it could be multiple different people, may control everything, or you might divide up different control between different parties. For example, if you're going to put in a trust your closely held business assets and then also some investments, you might have one trustee who has control over the business assets. So maybe they have control if there's voting interests in there or just how those assets are managed in general. And then you might have a different trustee who is going to handle your investments that are held in that trust. There's kind of different roles the trustees can have as well. And then finally, the beneficiaries. So these are the parties that are going to benefit from the assets that are held in trust. A lot of times when we're doing planning, it can be children, but it could also be a spouse. It could be other family members. It could be charity. So there's a lot of different people who could be the beneficiaries or entities that could be the beneficiaries. But again, this is who's really going to benefit from those assets that are held in trust. Slide 9. This is just an example of how this kind of looks. So we have the donor, the settlor, so they have the asset. What they're going to do is they're going to then, shift the ownership of that asset to the trustee. So for example, if we're giving a closely held business interest, we're going to probably put maybe, let's say, non-voting interests into a trust. So we're shifting that economic benefit of that interest to the trust. The trustee is the one who is going to manage that asset. They are the ones who decide based on how the rules of based on the rules of what the trust says. The trustee is going to decide, do we hold this in trust? Do I make distributions to the beneficiaries? They're the ones who are really going to control that asset. And then again, the beneficiaries are the ones who are going to benefit from the asset. And, trust can really have a wide range of rules that apply. It might say the trustee has the sole decision on whether or not to make distributions. It might say the trustee has to make annual income distributions to the beneficiaries. The trust also has different rules on how much information the beneficiaries might receive. So in certain states, you don't have to tell the beneficiaries anything about the assets that are held in trust. In other states, sometimes you have to tell them certain information. And in most states, you're going to have to put in the document, if you want to withhold any information, you're going to have to state that in the trust document. So there's kind of a broad range of ways we can put these assets in trust, and a broad range of how we manage these assets and how we hold them for the beneficiaries and what information the beneficiaries may receive.
Yeah, this slide does a really good job of explaining the difference or the value of a trust. There's other things we can talk about a trust as well, but it's if you could imagine $100 million S corporation, somebody says it'd be a good idea to make gifts of this S corporation now because I think the value is going to go up. You can imagine a donor saying, that's a good idea. I want to make the gift. But the problem is that when I make distributions, I'm not sure that I want my beneficiaries to have ready access to that cash, right? A business may decide, okay, we want to make a distribution because we've had a good year and the owner wants to take cash out of the business in a distribution. But he says, I don't want the 10% of my distribution to go directly to my child. They're not ready for it, or I want it to be protected. I don't want that it necessarily goes out to them. So what a trust allows us to do is to say, there's been a transfer for gift tax purposes. There is a gift tax return that's been filed. It no longer belongs to the donor, and you lock in that value. Again, borrowing from my prior example, maybe it's non-voting illiquid stock, 10% of a $100 million company with discounts. Maybe it's a $5 or $6 million gift that's reported on the gift tax return, and it belongs to the trustee. But the key issue is that the beneficiary, if a distribution is made, does not automatically, depending on the wording of the trust, does not automatically receive a distribution on those shares. So it could be that let's say in my example, it's a $100,000 distribution. The trustee can be given the discretion to retain those funds, invest them on the behalf of the beneficiary, right, and hold them and make distributions to the beneficiary. Could be at the discretion of the trustee, or you could even give some more instruction to the trustee. Only use these assets for educational and healthcare purposes, et cetera, et cetera. So we have a number of different people, settlers, giving us rules for when to make those distributions. But the long story short is that those two lines are bifurcated, right? The beneficiary does not have direct economic ownership if you use a trust. In the middle, we put a trustee who can be given instructions and discretion to make distributions of economics to the beneficiaries as appropriate.
Slide 10. When we're talking about trust, there are really two different types of trust that we're talking about. A lot of our presentation is focused on, prior to this, making a gift to a trust. Well, what type of trust are we making a gift to? You're going to make a gift to an irrevocable trust. So in an irrevocable trust, typically the settler is, not a beneficiary and not a trustee. A lot of times, though, the settler, beneficiary, and trustee in irrevocable trusts are going to be different parties. Now, not always. Sometimes you could have a trustee who's also a beneficiary, but it's important to note that the settler is generally not going to be a beneficiary of an irrevocable trust. And when we make a gift to an irrevocable trust, you are giving up rights to that asset, and you're giving up ownership rights. You are saying that the trust now owns this asset. So the settler is relinquishing the rights that they have in that asset, and they are giving title and control of that asset to the irrevocable trust. And, when we say irrevocable, generally you can't change it. Yes, there are some ways we may be able to change an irrevocable trust, but generally, again, it's an irrevocable gift, and you can't just go and say, oh, I actually didn't want to do that, and take it back. You made a gift, and now that asset is owned by that trust. And there's a lot of different names a revocable trust could have. It could be a family trust, a marital trust, a GST trust, a descendants trust, a dynasty trust, a GRAT. There are all different kinds of terms that we use for irrevocable trusts. But again, the important concept is, the settler generally is not a beneficiary, and they are giving up rights to an asset when they create that type of trust. The other type of trust is a revocable trust. With a revocable trust, the settler, beneficiary, trustee, they're all going to be the same person. There's really no shift in ownership or control when you title an asset into the name of a revocable trust. We do revocable trusts for estate planning after death. So we use these to avoid something called probate, which is going through a court process, and the court, is going to manage, how the assets are distributed after your lifetime. We want to avoid that. So we use a revocable trust to try to get around going to probate court. And so again, there's also no estate or gift tax planning to revocable trusts. Again, these are just used for planning after someone's lifetime, mainly to avoid probate and to say how you want your assets to pass. Revocable trusts can have different titles, but typically you'll see in the name, it'll say living or revocable oftentimes.
Yeah, this is a source of considerable confusion. People will say, I have a trust, and if they're in a revocable trust, they have made a gift during life. Those assets are generally outside of their purview, and they've generally filed a gift tax return because they've used gift exemption or made a sale to an irrevocable trust. Those assets are typically not available for that person. They are not also the beneficiary. A revocable trust is something that holds assets during your life and is subject to estate tax at your death. Now, it may be that it goes under the trust document, it goes to your spouse, which would eliminate estate tax at your death, but your spouse would be subject to estate tax. What makes things so difficult is that, we have a word, we use words like revocable or living, those sort of words for naming revocable trusts. And during life, again, typically the settler has control. The revocable trust uses the EIN. It doesn't avoid income tax. The income tax from any asset that's held in a revocable trust goes back to the donor. Though on top of it, so typically you will see these things being titled. People will title their assets to the revocable trust to avoid probate. The thing that makes this difficult is that a revocable trust can become irrevocable. It's just that you have to you have to pass away first. So a revocable trust, if someone has passed, could become irrevocable because while the settlor during his life had the ability to revoke it, he can't do that anymore because he's not around. So if he's not around, your revocable trust can become irrevocable. Long story short here, though, that when you have a revocable trust, because the settlor, the person who created it, is also a beneficiary and they're able to take assets out, that those assets do, we would say that they belong to that settlor. There may be some other instances in which, they have limited rights, but when you have a person who is alive and they have a revocable trust, that's typically another way to say those assets belong to that person.
Slide 11. So when you are titling something in the name of the trust, let's say you have a stock certificate and you have to title it in the name of the trust, what does that look like? Well, let's say Jason created an irrevocable trust and I'm the trustee. So you would title that stock certificate as Stephanie Dirks as trustee of the Jason Cahoot Irrevocable Trust dated 12/15/2025. So let's say he created this trust on 12/15/2025. If you see something that says UTA or FBO, UTA means under trust agreement, FBO means for the benefit of. So, maybe Jason created a trust for his son Patrick, and so he would title that as, Descendants Trust, FBO, Patrick J. Cahoot, so for the benefit of. So these are different, titles that you might see when you are titling a trust, or if, you might see a stock certificate that has these titles. And, as Jason just mentioned, revocable trusts, when the settlor dies, they often create other trusts under that trust document. So then you might all of a sudden, after someone dies, you'll now have a family trust, a marital trust, a survivor's trust. And it's really important to note that there's not going to be a new trust document. A lot of times people say, well, someone died and now there's this new trust. Where's the new trust document? There isn't one. It's almost certainly under the same document. So one document can create multiple different trusts for different people. Another example of this is you might have one document that creates several trusts for children. It might be an irrevocable trust, and it creates several trusts for children. So again, you might have one single trust instrument, but that trust instrument can create a lot of different trusts for different beneficiaries or different parties. And so again, kind of different things to think through if you are titling stock to a trust, or if you come across a stock that is titled in the name of the trust, some different things you might want to think through, or different things you might see.
Yeah, it can be really confusing for someone who operates in the corporate world, right? Typically, you would say a new entity has to get a new operating agreement. Like if you create a new LLC, you have to create a new operating agreement. The way that trusts are designed, many times they are designed, modern trusts are designed to operate really in perpetuity. The modern trend is to get rid of the rule against perpetuities. So oftentimes we're creating trusts that will be for issue forever, or 1,000 years, or 340 years, whatever the applicable limitation is. And so it could be, a trust for, it might have one beneficiary's name on it, or what it may be, the Cahoot Dynasty Trust. And then, children would have a separate trust, right? And then the provisions in the trust would say, upon the death of a child, it goes to that child's children, right, or grandchildren, and it could go into separate trusts for them. So you could have this dynasty trust agreement in place for several generations, and whenever there's a death, there's actually technically a new trust created, but it's still all the rules that apply to that trust are all under the original trust document. So we're still referencing, and in fact, at Foley, we're still referencing documents that were signed up by Lynn Lardner as witness or as trustee way back in the 1960s. So it's these trusts can go for a very long time. The document still stays in place, even though that technically you would say that a new entity or a new trust for the benefit of a new beneficiary, as grandchildren become great-grandchildren, new trusts are created.
Slide 12. So let's say you do have a trust that is a shareholder of the company, or a member of the LLC, and you need the owner's approval. So who has to sign on behalf of that trust? Well, like many things in the legal world, the answer is it depends. But typically, you're going to have the trustee sign that document on behalf of the trust. Again, as we discussed, in the previous presentation, the trustee is the one who is uh, has control over the asset. So typically the trustee is going to sign. However, you always have to look at the trust document, because sometimes we give the role of, signing on behalf of the company, voting a company shares. Sometimes we give that to a different party. And that party can have a lot of different names, but some typical names you might see would be a directing party, a trust protector, a special trustee. And so in the trust document, it would say that, for example, the special trustee, John Smith, has the right to sign on behalf of the company, to vote the shares that are held in the trust. And so you always want to look at the trust document to see, okay, who actually has the right to sign on behalf of the shareholder if the trust is the shareholder. And then the other thing you want to think through too is what transaction are you doing? If you're doing something major like a sale of the company, a merger, well, you have to remember that those business interests that are held in trust, they're held for the benefit of the beneficiaries. And so if the beneficiaries are really unhappy with what's going on, maybe they don't want to sell, they don't want to go through with this sale, well, they might try to bring a lawsuit. And so again, for certain transactions, does it make sense to get the beneficiary's approval? And again, looking at the trust document, does it give them some sort of right here? Should we have them sign off in addition to the trustee or whatever other party is designated in the trust as having control over these interests? So again, always look at the trust document when you are considering who has to sign on behalf of the trust.
That bullet points there because unfortunately, sometimes you learn through experience. And our experience is that if you have unhappy beneficiaries, they can gum up the works. And, if you're in the middle of a sale transaction, as you know, or a big transaction, right? Counterparties are not going to want to hear that. They will want to know that everybody is on board, and they will, when it comes time for signing and that sort of thing, a great deal of value can be lost if you have dissident beneficiaries who are creating an issue. So I think when you do have trusts, and if there's beneficiaries are not on board, one, it behooves the trustee to understand what's going on. Maybe there's some way to mitigate it. Maybe there's just something that we just have to understand. Our beneficiaries are going to disagree about this, and we just have to be on our toes about it. But I would say being proactive when you've got not everybody on the same page is awfully important. I personally have seen some transactions being unglued because we had a beneficiary who was not who was gave everybody cold feet in a hurry because, as Stephanie says, they do have the ability to go to court, and sometimes they can be, especially in the family business context where there can be all kinds of different sensitivities that can create a pretty big headache, and unfortunately, it could be at a time in which, like, for example, issuing debt or issuing shares or a sale, at which timing and the ability to have a united front is really important with third parties.
Slide 13. So one of the most important things for general counsel to be aware of and to think through is how you administer these trusts that are shareholders of a company. So let's say you have the owner of the business, he created an irrevocable trust, maybe he gifted some shares into that trust, maybe he sold some shares into that trust. Well, it's really important that you are maintaining proper records for that trust as the shareholder. That trust now has its own shareholder account. It's a separate entity from the original owner. They are not the same anymore. And so it's really important that you treat it as a separate entity. If the company is making distributions on the shares, making dividends, that needs to go into the trust account. It can't go into the into the original owner's account. A lot of times we'll do transactions for estate planning purposes where a business owner might sell interest to a trust and then they'll take back a promissory note. So let's say, as the company, you're making distributions. Basically, any distribution that goes to the trust will eventually be repaid to the business owner as a payment on the promissory note. What we don't want to see is if you're making a distribution and you're paying that promissory note, all the money just going directly to the settler. We need to show that any sort of distributions are going into the trust account, and then the trust is making a payment on the promissory note back to the settler. So we need to make sure that you're maintaining proper records, that the trust assets belong to the trust and the settler's assets belong to the settler. They're not the same entities. And this is really important for estate planning because if we don't do this, we can essentially undo all of the planning that we just did, and basically, all of those assets that we're saying, oh, they're no longer in the settler's estate and we're reducing this estate tax. Well, the IRS is going to say you didn't properly manage this trust, so everything is now going to be back in the settler's estate, and it undoes all that planning that we just tried to do.
Stephanie has now shown everybody watching this presentation exactly why we're doing it. We're recruiting the general counsels to protect the estate planner's hard work. So that's what we're up to here. Many times estate planners have very technical, we write trusts and we do these really complex plans. And for the most part, it's about like decreasing the amount of estate tax, addressing, mitigating the gift and estate tax, which we talked about earlier in the presentation is such a big issue if you're a family business, because that estate tax can be the difference between the next generation getting to work in this business or a sale, to be blunt about it. So we're looking for the general counsels out there to help us remind everybody at the company we're not typically involved in the issuance of a dividend every time or separate accounts or administering these trusts on a day-to-day basis. We're also, by the way, recruiting the CFOs, so hopefully we can get everybody on board with this idea that the trust is a separate entity. The long and short of it is, we talked about examples of when gifts make sense because they really can decrease the amount of estate tax due. We have some very nice planning opportunities that can dramatically decrease the amount of estate tax. The problem is, and those work, those options, those issues and mitigation opportunities work, but where it can be undone in an estate tax audit, and I think Stephanie and I have both seen this, where if someone doesn't keep things straight, if they disregard the planning, if they disregard trusts or separate entities, the IRS will come in and say, yeah, that was fine. That was a bunch of good lawyer tricks, but you disregarded them. And at the end of the day, you're telling us that the old generation made a gift in 2010, but if the person who made the gift continued to get all the dividends and distributions and controlled the shares and totally disregarded this planning, the IRS will say, yeah, that gift didn't happen. We're going to pull it all back into the older generation's taxable estate, and then you can pay estate tax on it. And by the way, in those last 14 years, the assets have appreciated by five times. Okay, well, if that happens, that's pretty much a really bad result. And so many times the IRS will give up on the technical arguments, but what they'll do is hone in on, hey, what's the actual what actually happened here on the ground. They'll look for, did the cash actually go to the trust accounts? Did you observe formalities, that sort of thing. Very similar for those of you in the corporate practice, very similar to the type of approach that may be taken by a piercing the corporate veil analysis. But I would say it's one step above that because the standard is significantly lower. The IRS can pull back assets and has some very broad powers. 2036 is an example of one. Very broad powers that they can apply to argue, at least assert that estate tax is due on assets that have otherwise been gifted under our planning.
All right, slide 14. In this next segment, we're going to be talking about business succession planning. And so, when working with owners of closely held businesses, there's really three different tiers that we talk through with them about, thinking through business succession planning. So, the first is ownership. Who benefits from the economics interests of the business? Who owns the company? Who's receiving the appreciation? Who's receiving the distributions, dividends? Who's really benefiting from the economics of the company? The next is control. Who has control over voting the interest? Who has the voting control? Who has the right to vote the shares, vote the LLC interests? And then the third tier is management. So who is managing the day-to-day activities of the company? Who are the LLC managers? Who are the officers of the corporation? And so thinking through succession planning, how can we divide these three different roles?
Yeah, the issue, of course, is that for our entrepreneurial clients who created the business, you know, they didn't have time for three tiers. It's been one person. He owns it, he controls it, and he runs the management of it day to day, right? So for him, it's been pretty simple, and it can be difficult to understand that that may not be the case in the next generation, right? Especially if you've had, especially if the idea is to give it to, I have two kids, I want both my children to inherit the business, or all kinds of different ways to share these three tiers, right? But it's interesting because entrepreneurs oftentimes don't. You have to go through this a few times because in their world they've always had all three tiers 100%. That's actually what usually makes their business very 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 successful, is that there's been instantaneous accountability for something on the management, and that equals a economic benefit.
Slide 15. So thinking through these different tiers and what we're going to do for succession planning for closely held businesses, a lot of times, again, they want their family to at least be in two or three of these roles, but maybe they're not all, maybe not all family members are in the same roles. So things we're trying to think through when we're thinking through this is, one, okay, how do we maintain family ownership of the company? So we do want to keep, the ownership within the family. And then also, how are we going to resolve disputes among the different family members? If they do have different roles within the company or within those three tiers we talked about, how are we disputes among them so everyone is, generally happy with how things are going? So one thing that we often do is we separate stock ownership from control. So a lot of times we may transfer stock ownership to, let's say, a younger generation, and then we'll retain control with the older generation, or maybe we'll give control to a specific party or a specific member of the younger generation. Maybe there's one family member who's really involved in the business and we want them to do a lot of the decision making. Maybe they'll have voting control, or maybe we want them to have management decision making. But we do want all of the children to benefit from the economics of the company. So they'll still have ownership, but maybe they won't have any control over the daily decisions or control of voting the shares. So there's different ways where we can, still give the economics to all family members, but we are dividing control between different parties. And again, you want to make sure that everyone is generally happy. Everyone is, maybe sure that they, they are able to manage the company, or they are able to make certain decisions without other family members trying to block that or be upset about it.
This can be an area. I mean, it's very sensitive and complex. It's pretty easy to say that we're going to make a gift of non-voting shares, right, to the younger generation. Older generation will maintain the vote and control of the enterprise for a significant period of time. But for estate tax purposes, to avoid the estate tax, we are going to gift the non-voting shares. I'd say we do that many times. Not terribly controversial. It's usually gifted to a trust for various purposes, but at the end of the day, control remains with the older generation. The second part of succession planning, though, is that when the older generation is not around and not able to control it, who gets to control the company? And this is where there can be significant, one, just misunderstandings, because people think I'm getting the stock, Why am I not, we'll get the stock equally. I'll have my say at the corporation. And that's where the older generation has to make some decisions about who is going to actually have a say, right? Everybody may get distributions equally, if distributions come out of the company, but who gets to have a say in the governance of the company? And that's where older generation may say, I'm going to set up some mechanism by which uh, we would control or have a limitation on the people who are going to have a say on the board of directors, voting trust, or that another mechanism to really say, look, there's going to be centralized management of this company by people who share the vision of the older generation, which I have to say oftentimes boils down to the older generation reinvested in the company. That's why it's been successful, and they want to continue with that approach. And they're okay if other family members have ownership, they have economic ownership, but they really want to make sure that that vision for uh, family reinvestment in the business is carried out. That's where you may say, okay, we're going to have much more of a focused control group here, as opposed to just essentially everybody in the family sharing it.
Slide 16. So, as Jason just alluded to, there are a lot of different ways where we can separate this idea of control from economic ownership. And as he just discussed, a lot of times it is something as simple as maybe we'll do, voting and non-voting stock in a company or in a corporation, or we can also do non-voting and non-voting interest in LLCs. Older generation or the child who's involved in the business, maybe they have voting control, and maybe we're passing the non-voting interest to other family members. There's a lot of other different ways we can divide this idea of control as well. You can put interest into a trust, and again, the beneficiaries might be all of the family members, so they're all receiving the economic benefits, but maybe whoever is the trustee or that specific party, someone is designated to vote the shares to manage those business interests. So, everyone's benefiting economically, but not everyone is making the decision on what happens to those business interests. We can also do a specific type of trust called a voting trust, and that is where ownership generally it remains the same, but again, you're designating a specific party to vote the shares, and we're able to do that under state statute most of the time. So again, kind of a lot of different ways we can do this, but just keep in mind that there's all different, whatever the situation is, we can often think of a way, okay, how can we do this so everyone is generally happy, and we're the person who needs to be making decisions is the right party, and everyone is benefiting economically from this company. Slide 17. So, the other important part of a closely held business is that you really want to keep ownership within the family. And so one way that we do this is to pretty much always have some sort of buy-sell agreement incorporated, whether it's a shareholders agreement or incorporated into an LLC operating agreement. But really what we're trying to do here is to make sure that if one party wants to transfer their shares outside of the family, the other family members have the ability to buy those shares. We also want to prevent inadvertent transfers to creditors or to ex-spouses. Some party that we don't want becoming an owner, we're going to make sure we have a way to avoid that. Another benefit of these type of buy-sell agreements is that maybe one family member is just not happy and they just want out of the business. And so maybe we can create a way where, they are able to sell the company or sell their interest in the company back to the company, or maybe, sell it to other family members. And there's, different considerations there, whether there is liquidity within the company or within other family members to buy that interest, or, how are we going to price it? How is it going to be paid, lump sum versus a note? So a lot of different things to think through. But again, we just want to make sure that we're keeping ownership within the family, and then maybe giving the family a way out if that's what they might want.
Yeah, the buy sell, not typically terribly controversial, right? To say like this family has to have the ability to, if there's any transfers outside the family, basically the family members have to maintain an ability to get those shares back so that there's not a third party owning this company. I'd say that's a fairly, very common, almost non-controversial matter when we talk about that with clients. the possibilities to uh, make allow the shareholders to make the company buy back the stock, right? That can be a little bit difficult because the company may not always have liquidity to do that, especially if the company's deciding, you know what, we're going to go down an investment. We're going to go down a road for the next 5 years to do reinvestments in the company as opposed to paying dividends or having cash to buy out shareholders. There can be a real cash crunch there. Um, but it strikes me that that's where the balance in creating these plans comes from. It's typically some element of we want X, Y, and Z to be in control because they're involved in the business. They know the business the best. As opposed to other family members who may just be worried about, they just want a dividend, right? They may be very short term thinking as opposed to people who are involved in the business, maybe a little bit longer term thinking. But of course, Stephanie and I, we always think in terms of checks and balances. Our mentor always talks about checks and balances. One check could be, okay, well, if there isn't liquidity coming from this company, then the other shareholders have a right to cash out of the company for some amount, right? So they could say, you know what, this company, I need to get out of this company. Um, and so, company, you're going to buy back my stock at a set price. I would say there's also the advantage there that there may be a argument that that helps avoid disputes. My minority shareholder saying, I don't have control. You guys are sticking it to me. I've got to pay these taxes on flow through if it's an S corporation, but I don't get liquidity. Um, that can really be a sticky situation. Um, and putting possibilities for liquidity into a buy sell could create an avenue for that to be resolved without significant disputes.
Slide 18. One really important concept for closely held businesses is this concept of marital property, and it's something a lot of people I think don't understand or fully aware of. So in community property states, it doesn't matter how your assets are titled. Once you're married, everything that you acquired for married is going to be presumed owned one half by each spouse. So I might, let's say I bought a house with my husband. I'm in Wisconsin. We are a community property state. If we buy a house during our marriage, but I title it in my name, I that even though it's titled in my name, my spouse still has a one half interest in that property. Now, title does, determine control during life. So I might be able to make certain decisions with regard to that property, but my spouse still has an interest in it. So if he's not happy with something I've done, well, he can come after me and say, hey, I have one half interest in that property. It's our marital property. There are, several states that are community property states. Wisconsin is one of them. Some of the other big ones include Texas, California, Arizona, Washington, I believe. So there's a few different states that have community property, and it's important to be aware of this concept, especially because, and we've seen this before, where you have a family business, and that interest was acquired while this person was married, and inadvertently that business became one half owned by spouse. And when if planning wasn't done properly, that may not have been the family's intent, and it can create a lot of issues. And we've definitely seen this in our practice. Now, there are certain exceptions to marital property. For example, if you create a trust for someone. So if I create a trust for my child, any assets I place into that trust would not become marital property of my child's, spouse, unless the interest in that trust were then distributed out. Then potentially it could become marital property. Technically, anything you own prior to the marriage is not marital property, but you have to be really careful, because anytime you mix property, individual property you had before the marriage, or a property that was maybe gifted or inherited, also not marital property. But if you mix it with your marital property, well, then it becomes a little more dicey and could inadvertently become marital property. So you need to be keeping proper records if you don't want certain assets to be marital property versus assets that you do want to be marital property. And just kind of, for closely held businesses, a lot of times we'll take certain measures to ensure that assets, the closely held business in particular, doesn't inadvertently become marital property if we don't want it to. So we will do this using trusts, using prenuptial agreements where we'll state, the family business is not going to become a marital property upon marriage. And again, going back to the shareholders agreement, really to ensure that if something were to become marital property, we still have a way to kind of buy out the spouse and get that interest back into the family.
Yeah, one of the least favorite things in my practice is doing prenuptial agreements, even though it's related to such a happy event, the marriage of a client. But I think for general counsels, that's often their job is to find a person to write the prenup and someone to represent the other party. Typically, a prenup is, our best practice is to have both parties represented by separate attorneys. I think that they can be done in a way that says, okay, you're recognizing that these are assets brought to the marriage, they're inherited and gifted assets, right? They're family assets, and everything else will stay the same under state law, except that the business will stay out of a divorce settlement. It will not be subject to division, and you can go further and say it will not be referenced in any decision for support or maintenance. I think those are easier prenuptial agreements to negotiate. We do see a significant number of them. You kind of have to counsel the parties that it's not a huge deviation from state law, because, as Stephanie noted, we do have exceptions to marital or community property, and those exceptions apply generally in most states that have community property. So I will say that we do that. That is, frankly, reminding clients, again, on a day-to-day basis, which can become the general counsel's role or CFO's role, to remind people, shareholders, that family members, that, this does apply. And if you take that step to intermingle assets, move assets to jointly titled accounts, that sort of thing, the ability to recover those assets, or those assets may be, we call it transmuted to marital property, and they would belong one half to the other spouse. I would say that there's in long-term relationships or areas where we're not involved in, and it's this, nobody focuses on this, it can become quite a issue if there is a dissolution or divorce.
And one final note I do want to say about marital property, especially for general counsel, is generally just always have the, spouse sign and consent to certain actions. If you have particularly a shareholder agreement, always make sure that you are having spouses sign, even if you're in a state where it's not a marital property state, because people move around all the time. You don't know where someone might move to or where they came from, and something might inadvertently become, again, marital property. So it's just always a good idea to have a spouse sign off on something.
Yeah, especially if everybody's in agreement, right? It's like people, sometimes our business lawyers ask us, do I need the spouse? And you could just see issues occurring, and if everybody's happy, it could be valuable. It could be valuable later on if there was a disagreement.
Slide 20. For this next segment, we're going to just briefly discuss the rules for S corporations. A lot of closely held businesses are organized as an S corporation. So an S corporation, unlike a C corporation, does not pay federal income tax, and instead the tax all flows through to the shareholders. And this oftentimes can be a valuable benefit. I think we used to see it more, but now that income tax rates have gone down, we are seeing more family businesses converting to C corporations instead of S corporations. But if you do have an S corporation, there are certain rules that they have to follow. The first is that you can only have one class of stock. And so every shareholder has to be entitled to the same dividend and liquidation rights. And it's important to remember this and to be careful. There are certain ways where you could inadvertently break this rule. For example, debt in some circumstances could be considered stock, and you don't want that to happen, because now all of a sudden you might have two classes of stock. Although one thing I do want to point out is that you can have voting and non-voting stock. That's still considered one class of stock because the shareholders are still having the same, dividend and liquidation rights. So that is permissible to have voting and non-voting. A lot of times we do get questions if we want to um, recapitalize an S corporation to voting and non-voting, and wait, can we do this? Is that permitted? Yes, it is. S corporations also are limited on the types of shareholders that they can have. So certain types of trusts cannot be an S corporation shareholder. You also generally can't have foreign owners or partnerships as S corporation shareholders. But going back to the trust issue, there are types of trusts that can be S corporation shareholders. They are called grantor trust, SBITs, QSSTs. So certain types of trusts can be an S corporation shareholder. Basically, you have to have certain provisions in the trust that are allowed under the statute for that trust to be a shareholder. Typically, the income has to be taxed in a certain way to the grantor or to a beneficiary. But again, you would want to review the trust document to ensure that that trust can actually hold S corporation stock. Finally, S corporations are limited to 100 shareholders, but keep in mind that family members, spouses, and trusts for the benefit of family members and spouses are all considered one shareholder for that 100 shareholder limit.
A number of, as Stephanie said, it used to be much more important. Although the companies that want to be S corporations, it's important that they retain their S corporation status. And again, there could be hidden traps as to maintaining that status, especially with regard to trusts, but then also this one class of stock. The issue is that there always seems to be a reason why we need to have a second class of stock. We want to issue incentives, or somebody gets a different liquidation preference or something like that. It's just not allowed. And the problem is that people are very creative about finding ways around that. And of course, in tax land, we always have this thing called economic substance, in which we're worried that, oh, wait, the substance of that rule actually did create two classes of stock. That's an issue. So that can be an issue, especially when it comes to sale of the company. Now, I know most of our family held businesses will never be sold. But if there is a sale, the ability to say that this corporation is an S corporation will become pretty big issue when it comes to reps and warranties on the tax consequences that the buyer is going to receive. So this can be an issue that comes up, a decade, 2 decades from now, but it can be a pretty valuable issue for the family if there's some sort of transaction.
Slide 21. For the next segment, we're going to be talking about what is a family office. And this is really a broad term that can encompass a lot of different situations for different families.
So I'm the chair of the family office practice here. I think that I would have a better definition of what a family office is. I think the best way to say it is it's an arrangement that families make because wealth, investments, business interests, all the sorts of things that go along with that are awfully complicated. And they are looking for a way to manage it. That's typically, someone or some nexus to say this is how we're going to manage these, manage our complexity, right? It can be someone sitting in an office. It can be hiring what's called a multifamily office to look after this stuff and manage all these different trusts and all these different entities that people like Steffi and I create. But they're different arrangements, very broad activities. And then we can kind of think a little bit harder in this presentation about, what does it mean when we want to think about tax minimization with regard to the family office? So moving to slide 22, again, these things do all kinds of things, or they may do one thing. So we have family offices that are hyper focused on accounting and tax prep or tax planning. And then we have family offices that have moved much more in the area of direct investment. So that means going out and maybe buying a company akin to a private equity investment that may not have much to do with the family business, but instead it's just a business that the family wants to own, or investment management. So we have family offices that hire, I would call a CIO, a person who's making investment decisions, hiring managers, or in some cases, selecting stocks, right? So And then we have people who their family office's major job is to hire and supervise an investment advisor. And most of those activities of the selection of investments are actually handled outside the family office. Certainly, family education is an issue, estate planning, and then many times the family office is involved in philanthropy, managing the family foundation, and then all kinds of different services that the family may need. Moving on to slide 23. When we say family office, many times what people are talking about is setting up a separate entity that is going to handle this, right? For whatever reason. It may just be because it's not a good idea to have it in the family business. It may be because the family business was sold and that the family operations are significantly outside of any particular family business. The issue here is that Section 212 says that deductions for investment expenses as opposed to business expenses are not deductible. Business expenses are deductible under Section 67. If you are simply investing assets, that is to say, hiring a CIO or hiring an accountant or someone like that for the purposes of completing these types of activities, you have Section 212 deductions, and those deductions are limited. They're not allowed. You can't take those types of deductions since 2017. So those would include things like investment managers, outside investment advisors, and that sort of thing. Many of the things that you would consider to be in a family office. So what's the workaround? On slide 24, we talk about what people will refer to as lender management or the lender bagel case. This is a 2017 case that came out, so it's not been terribly recent. And what happened there in that case was that the family got together and created both a family LLC and a family office. So that was the family office was lender management. This is the family that founded Lender's Bagels way back when. So what happened was that one of the family members ran lender management. It invested and received a profits interest from the family investment LLCs. A family office profits interest is not subject to a deduction because a profits interest doesn't create a deduction. A profits interest is just a reallocation of profits from an investment to say that those profits now go to the person who receives the profits interest, carried interest, or promote, are different words that are used there. Under the Soul Diamond case, a profits interest is not subject to tax until the profits materialize. In addition, it is not a fee, and it's not a deduction to the family investment LLC. Instead, what it is just a reallocation of profits. The profits just do not go to the family investment LLC; they go to the carried interest. The court holding here was that this was allowed. So instead of the IRS, which the IRS said, this profits interest is just another way. We talked about economic substance. The economic substance of this profits interest is that really what it is a fee. It's a fee from the family investment LLCs, which are is the rest of the family investing together. It's a fee paid by the family investment LLC to another family member for investment services, which, as we just discussed, is not deductible. So if it's a fee, if it's recharacterized as a fee, it's not deductible. But here the taxpayer won. So the taxpayer won, and the court held that the management services entity was actually a separate business enterprise, and that this profits interest was respected. So because it's a separate business enterprise engaged in the operations of actual investment services being provided to family investment LLCs in exchange for these profits interests, the profits interest, the amount that went to the profits interest was not income to the LLCs without a deduction. It was essentially just reallocated to the family management entity. The family management entity was allowed then to pay compensation, pay expenses, and those business expenses within the lender management, within the family office, were deductible because they're operating a separate business. And that business is the managing the family LLCs. So as I discussed, this result would not be allowed if the family LLCs paid Keith directly, the person who was running the family office, or if the family investment LLCs were treated as though they were paying a fee for services, because that fee would not be deductible, right? So they would have income, they would recognize the income paid to the family office, and then they wouldn't have an offsetting deduction. So moving on to slide 25, this is the lender office, the lender management model, and as a general matter is how family offices are set up if there is a need to use a carried interest. So you have many family members or trusts for their benefit investing in a collective investment fund. That investment fund is investing the family assets down there in the green circle, or oval rather, and the investment fund is paying, to the extent that there is a profit in the year, that investment fund is paying part of the profit over to the family office entity, which is its own taxpayer. It's separate, and you would say that it's receiving a carried interest in exchange for providing services to the investment fund, and that its expenses are business expenses because it's providing a business service to the investment fund in exchange. Sorry, it has income for its carried interest, and its expenses are business expenses in pursuit of performing its services. So we have to think of things separately. And again, it's another case of maintaining separation between these entities, and then being very careful about structuring this in a way that makes the family office entity truly a business enterprise that supports the an investment fund or funds for the family. Slide 26. We want to talk a little bit about company foundations. Our general counsels are often involved in answering questions about the company foundation. A company foundation is a 501c3, so sometimes people are confused about this, but it is a separate 501c3, and in fact, it's usually, company foundations are usually subject to another set of rules called the private foundation rules. The two rules that really matter are the self-dealing rules and the taxable expenditure rules. And I'd say, bullet point here that these rules apply in a way that prohibit certain transactions that you would think, and I would say most people think, should be okay for a 501c3. And in fact, they prohibit transactions that you would say benefit the 501c3. But because of these special rules, they were adopted in 1969, haven't really been updated much except to increase the penalties. They are prohibited. These types of transactions are prohibited. The two or three things that come up quite a bit for company foundations are whether the foundation can satisfy a pledge made by the company or its owners, officers, and directors. What do I mean by this? Well, if the company says, I pledge $100 for the, Stephanie's on the Curative board. So on the to Curative, I pledge $100 to Curative. Well, that's a debt of the company. It's a binding pledge by the company. So the foundation cannot pay that pledge. Why? Even though the foundation is making a 501c3 contribution to Curative, it doesn't matter, because what the foundation is also doing with its money is it's paying the debt, the legal debt of the company, right? And the self-dealing rule says you can't use foundation assets to pay the debt or to use the assets for the benefit of the company, the people who made the contributions to the company foundation, the private foundation. So we have a major issue there. Typically what we will do is, one, ask the company not to do that, or have the company rescind the pledge, and maybe the foundation can make it. But it's a key issue to be very careful about when you're making a pledge, when somebody is out there making a pledge, including family members who would also be subject to this rule. If they make a pledge for a 501 to make a grant to a 501c3, it is not necessarily the case the foundation can make the gift, right? Because they would be, under the rules, they would be paying the liability of a disqualified person, of the company or of one of its shareholders, which is not allowed. The other issue that comes up quite a bit is we have a lot of clients asked to attend galas and golf outings. The general rule, if you're an individual, is that if you make a contribution to a golf outing or gala, and let's say the golf is worth $100, you make a gift of $1,000, you get an income tax deduction of $900, right? It says right on your receipt, your gift is worth $1,000, but you got a quid pro quo of $100 for an income tax deduction of $900. This does not work for private foundations. I understand a lot of people do it, and I'm not sure that the IRS is very proactive about policing it. But the issue is that because the private foundation paid for this benefit for the donor, right, for the disqualified person, for the company or the shareholder, the company or the family member, that benefit cannot go to the company or to the family member, right? That $1,000 went to the gala. The benefit that came back has to belong to the foundation. It cannot be used by the company or by the typically the shareholders of the company or by family members of those parties. Or if the family contributed directly to the company foundation, it may not be able to be used by the family that contributed, the donor or the family members of the donor who contributed to the foundation. So this can be in some pretty tricky situations. We do help people work through those. But I would say that if the idea is that the gift is going to be used for a golf outing, it's better if the individual or the company uses company funds or individual funds to make that gift. Lastly, slide 27. It is allowed that the company can receive recognition related to foundation grants. So back to my gala, if the foundation gave $10,000 to be recognized as the sponsor of the gala, and they didn't, and the company did not receive any other benefit, no tickets to the gala, no any other quid pro quos, that is allowed. So the company can make a gift to be a sponsor, right? That is okay, even though you may point out, boy, being recognized as a sponsor may have some intangible value, but the regulations in this area say that an intangible benefit is okay. So for example, here my example is the recipient can recognize the company in its annual report, on its website, on a plaque, or on the name of a building, which could be a significant value. The foundation can use the company's name and the company's logo. It is allowed, private foundations, company foundations are allowed to pay family members or shareholders, directors, to be directors and officers of the company foundation. It must be reasonable, but it can be done. And then lastly, just keep in mind, on a company foundation, the Form 990 PFs, which are the tax return that has to be filed, those are publicly available. So if there's something that's going to be controversial, and we live in a time in which things can become controversial, just keep in mind that it is publicly available, and people do take a look at those tax filings. With that, we've come to the end of our presentation. If you made it this far, we appreciate it. And if you are, if something in this presentation gave you a question or thought, please reach out to Stephanie and I about follow-up.